Welcome to Out of Court and Out of Conflict, presented by Wasinger Law Office.
Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions by Wasinger Law Office. Join us today as we unravel legal complexities and secure your family's legacy with experienced attorney Matt Wasinger. I am your host, Kevin Rosenquist, and today's episode is Choosing the Right Guardian for Your Children, Florida's Legal Insights. Matt, welcome back.
Thanks for having me, Kevin.
All right, to start, can you explain what guardianship for minor children means in Florida?
In Florida, it's quite literally you're naming the people who would take and raise your children if you are unable or have passed away in some instance.
Why is it important for parents to designate a guardian for their minor children in their estate plan?
Because if you don't, the judge is going to decide. The judge is going to decide who's in charge of your kids. And that can be okay sometimes, but most of the time, a judge isn't going to know what is most important to you and who you think is the best person to raise your children, because a judge is doing what's in the best interest of the child. That's their ultimate goal. But they're also doing it based on very limited information and limited interactions with the people that may be trying to be the guardian or may just be, one of the options to be the guardian. And a colleague of mine has given me permission to share this. She's used her own situation as an example, which is on paper, she's got two sisters. And on paper, one of them is an executive, very successful, has everything organized, and looks like the perfect candidate. But if it was up to her other sister, who was a bartender, a little less put together, at least on paper, and, not that this should matter in the scheme of things these days, but it's still, tattoos, everything, just not going to present as well as her other sister. But her sister that was not as presentable to the court maybe, or on paper, was who she would wanted to raise her children. Is because she knew she would raise them exactly the way that she wanted them to be raised. And her other sister, while she didn't think she wouldn't necessarily, she thought it would be a better environment for them with her other sister. And if you're weighing these two people in front of a judge is going to go, you know what, I think it makes more sense for the executive sister to handle all this stuff. And that's what ends up happening, is they are looking at the best interest of the child based on what they can tell from the limited interactions with the people that are up there. So you want to make sure that the people that will uphold the values and raise your children exactly the way you would want them to be raised as the people named in your guardians. Otherwise, you don't know who's going to end up doing that.
And what kind of factors does the judge look at when they're having to make that decision?
Well, they're always going to be looking at the home life specifically. And then, depending on whether the estate has left any money behind for the ability to raise those children, then financially they're going to be looking at those options as well. Who is in the best financial position? That's why we always recommend all of our clients, even if you just get some simple term life insurance to cover it until their children reach the majority age at the very least, to help cover the burden if anything happens to you for your children to be raised, whether that's just for your spouse or significant other and you're not there, or if you both go, that the guardian shouldn't be the one having to financially cover your kids while they're raising them. Or at least that's the way we try to set it up. We want there to be some funds there, because if not, then a judge is going to be weighing heavily on who's got a financial ability on top of the factors of the home life that they currently have, and maybe the jobs, the availability. If they're traveling a lot, maybe that's not an option. So it's really a case-by-case basis. And it's always going to be the overarching test is best interest of the child. And, and sometimes that can come down to the judge that's handling it. They might have a different idea of what's in the best interest of the child than another judge. It's really a crapshoot at that point to how it's going to go. And especially if you've got specific people in mind that you would prefer to handle it, and specific people in mind you'd prefer not handle those duties.
Yep. That, which might be even more important to some people, to be honest with you.
Right.
Yeah. So what is the process for formalizing guardianship after a parent's death or incapacity?
If you've already executed nomination of guardian documents, then those documents work like a power of attorney. They are effectively in place. You're going to need to carry them everywhere, show everyone everywhere, and and get that handled. But if you don't have anything in place, you're going to court to have a judge, officially appoint you as guardians, legal guardians of the children. I mean, so that's why whether the documents are executed or not makes a difference, because you always want the documents there for the purposes of maybe rubber stamping it if you need a court order for anything. But without it, the process is a lot different.
Can parents nominate more than one guardian for their children? Like, is there do you do kind of like a hierarchy? Is, this is my first choice, second choice, that sort of thing?
Yeah. And we always try to get, and sometimes it's just not possible for people, and we understand that, but we always try to get at least a guardian and a backup. And hopefully we can do a guardian backup and a backup to the backup. And then you're kind of putting them in the order that you want. And one of the ways that having an attorney that's experienced in this versus maybe just a DIY document is, we'll also talk about, okay, let's say you've chosen your brother and sister-in-law to be the guardians of the children. Well, what happens if they're divorced or one of them dies? Does it stay with just the brother, or can the sister-in-law raise them on their own? And you need to set that order out. So Jane and Jim together, or Jim alone. And if not, then to Matt and Kevin together, or Kevin alone, right? So you're designating not only who's coming in what order, but who ultimately, if there's a separation of any kind and you've nominated a couple, who's going to be in charge if that couple breaks up for whatever reason.
Yeah. And also, I mean, I suppose it could be like, a couple, if my brother and sister-in-law were our first choice, which I think actually they are, then what if my brother had passed, what if she doesn't want to deal with that anymore too, right? If she doesn't feel like that's something she can handle anymore, then would it go automatically to the next one? I mean, I'm assuming she could say no, even if she's listed as the
right.
person, right?
The language is essentially if they are unwilling or unable. Less like the parents that are unwilling, the people that you might
now
be
it applies
choosing to not take up that mantle. Unable or unwilling, then it would go down, to your next choice, or at least hopefully, if you have a second choice. If not, then you're going back to court like usual. So
yeah,
that's why we try to have at least, if we can get 3 names on there, that's what we're going for, and in a sequential order.
Right. What should parents consider when choosing a guardian for their minor children? Are there any legal or practical factors that might influence that decision? One
of the things that we point out is the most important thing is choosing someone that would raise your children the way you want them to be raised, not the way that they themselves, maybe they raise their children differently, but that they will do their best to make sure that your children are raised the way you want them to.
Right.
And that we've put together an instruction of guardians package where we have parents fill those things out. So everything from education to, jobs and business to spiritual or religious preferences in terms of the way that they're raised. Some go as far as laying out vacations and, extracurricular activities they'd like to be involved in, or philanthropy, and all different things they list out for their guardians to know, okay, this is what we want to do. So that's the number one thing we state, because it's going to be an incredibly difficult time for your children if this is ever coming into play.
Of course. So
some people are like, well, we really want them to be, stay here in let's say in Orlando, Florida. We want them to stay in Orlando, Florida. Well, that's okay. That's a characteristic that you should think about. But if there's no one in Orlando, Florida that you think is going to raise your kids the way you want them to be raised, then maybe that's not a criteria we want to nail down as part of the decision-making process. And those are some of the factors that we put in place or we emphasize. And the other thing is we try, if possible, especially if you're dealing with a trust, for the trustee to be different than the guardians. And the reason for that is if you're leaving money behind that needs to be handled in a specific way, sometimes the guardians aren't going to be the best people to make those decisions regarding how that money is spent. Or it's nice to take that burden off of the guardians, right? So if you've got you're dealing with a a teenager that thinks they should get a brand new car, and the trustee is separate from the guardian, say, sorry, we don't make those, we can't make those decisions for you. That's up to the trustee handling your trust and the money that's in there. And if they say it's not okay, it's not okay. So it relieves one aspect of handling the finances by having a separate trustee over the guardians, if possible.
With things like your example about, I want my kid to stay in Orlando, if it's a few years after you're gone and the guardian wants to move for whatever reason, I mean, they're free to do that, right? It's not like a binding thing where they have to stay in a certain city.
Right. And that's another thing. And you could, technically, although I don't know how practical this would be in actual practice, but you put, as long as they're in Orlando, this is our first choice. If they decide to move, we want to put them with somebody else. Mm-hmm. Now, I never recommend that specifically because you are just uplifting their lives multiple times with different people over the course of it. But that's why, while location should matter, especially if your family's all around there, if you've got the ability, you really want them to stay somewhere, choosing somebody that you believe isn't going anywhere is probably the best bet. Mm-hmm. Or just making sure that they're with the people that you want them to be raised by is the overarching criteria that we try to emphasize.
What are some of the challenges that may arise in guardianship cases in Florida, particularly if the child's extended family members might disagree with the parents' choices or don't feel that's in the best interest of the child?
The short answer is tough. If you've got all your documents put in place, right? Like and if they're following what you have laid out in terms of the instructions to guardians, and why we encourage all of our clients to fill those out, is they've got a pretty good sense of what they're supposed to be doing and how they're supposed to be raising the children. If there's evidence of something, of some real impropriety going on, then the family's going to have to go to court to get them, removed and new guardians put in place. So it's not an easy or cheap process, which means if you're doing it, hopefully they're doing it for the right reasons, instead of just trying to maybe get control over the money that was left for those kids, or, just they don't like the people that they chose, whether it's someone that's not a family member, which is another thing we tell people. Everyone thinks that they have to name a family member to raise their children, but sometimes maybe that's not practical or the best scenario for you and your family, for your kids to be raised.
Can arrangements be temporary, or do they always have to be permanent? Are there different levels?
The law only provides for, specifically, if you're naming your own guardians, permanent guardians, right?
Okay.
There's scenarios with the court where they can put temporary guardians in place for things until permanent guardians can be named. But what we do, and we've created temporary guardian documents too. We essentially create the same thing as nomination guardians, but we're putting temporary guardians in place for the purposes of, let's say maybe your permanent guardians live in California and we're in Orlando. They're not going to be there right away, right? So if we have some temporary guardians there in town or close by that they can get there right away, that helps prevent the kids from having to maybe go, spend a day in the police station or spend time with Child Protective Services, because until that legally named guardian can show up and take the kids, technically the police or whomever is dealing with the situation are supposed to send them to DCF, which Child Protective Services. So we put these in place for the ability and give them a medical power of attorney authority to be able to handle things in the short term until those permanent guardians can arrive. And maybe the permanent guardians do live in town, but let's just say they're on vacation somewhere. We're just trying to close the gaps until those permanent guardians can get there.
How does guardianship impact a child's inheritance?
Well, it depends on how you've got it structured, right? So a will, in almost all cases, that money is going to go outright to the guardians for the purposes of raising the children. And so that means the guardians are in complete control of that money. It's in their bank account, essentially, unless, there's some caveats to that with a will, but mostly the money is going directly outright with a will. With a trust, you have the ability of putting a revocable living trust, you have the ability to put the money down to your kids after you pass in an irrevocable trust with a trustee named to handle that money, who has a fiduciary responsibility to handle it in the way that the terms of the trust are set up. So that is a much more comprehensive and a better way to ensure that the money that you've left behind is actually used for your children the way it's supposed to be used.
Okay.
And so nominating guardians along with those documents is important.
I feel like every time I talk to you, I have a list of things I need to start looking at. Things I just don't think about that I really need to think about. Important stuff, no doubt. All right. Well, thanks for tuning into Out of Court and Out of Conflict with experienced attorney Matt Wasinger. For more information or to connect with Matt, visit wasingerlawoffice.com and be sure to like, subscribe, and give us a review in the comments. Matt, thanks for being here. Really appreciate all the insight.
Of course, anytime.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.